Hi there, welcome back to Family Law Assistance. And listen, I hope you guys are doing well. It's been a weekend. I mean, the rain has just been chucking it down. So I don't know what it's like where you are. But today, never mind that. Today I'm coming at you with a live all about the top 5 things that we're asked. And I sort of trawled through back all of our DMs, our messages, our emails, the posts on here. And look, I can tell you how official this live is going to be. I've got a clipboard. I've got a clipboard. So that instantly makes this really official. So without any further ado, and in no particular order, I might add, because I wasn't that great that I did the statistics on it, but I have pulled together the top 5 things we were asked. Okay, so number 1, we're asked a lot is, how do I defend against allegations? Now, some of you, if you've seen my video from yesterday, no, it wasn't yesterday, it's Monday, Friday, whenever it was, it all blurs into one. If you saw that video, I talked all about allegations of abuse. Fact, every single family law case that we, the team, the court deal with, all have allegations of abuse. Without bar none. You know, it's human instinct to want to rebut every single allegations, and often your statements in court can often be I call it the yeah but statement. Yeah but. Thing is, if you are facing allegations of abuse and you're on the receiving end of allegations of abuse, I just want you to bear one thing in mind, and that is the ex may have put forward allegations of abuse, but unless the court take it seriously, then you don't need to investigate it. You don't need to rebut it. The number of statements that I deal with, that many of the pages can be disregarded by simply saying, I refute the allegations. If you're on the receiving end of allegations and the court are not taking it seriously at the moment, then learn this phrase: I refute all allegations. 3 or 4 words, and it just deals with the other side's allegations. Now, those of you that saw my last live, I went into finding of facts. I went into how the court will address allegations of abuse. So if you are looking for a little bit of nighttime reading, I would suggest Practice Direction 12J. That is the legislation which allows the court to investigate allegations from the get-go. There's a whole procedure in court dealing specifically with allegations of abuse. So if you didn't check out that live, check it out. Allegations of abuse, the court will got their own way of dealing with it. And there's a whole procedure which, yeah, I know kind of puts contact matters on ice for a little bit, but it does draw an end, whichever way the cards fall, an end, and draws a line under that. Okay. So number 2, and again, these are in no particular order. I just pulled the top 5 things that we were asked. Like I said, how impressive is this? I've even got a clipboard. Did I just mention I had a clipboard? Yeah, the things that amuse me these days. All right, so number 2 is, can they stop me from seeing my children? It's a little bit like a burglar alarm. You can put the fanciest burglar alarm on the side of your house, but it's a deterrent. But if a burglar is going to want to burgle your house, they're going to find a way. A fact, 9 times out of 10, people stop contact without a legal basis for doing so. So they're not obtaining court's permission, they're not reporting it, we're not reporting instances to social services, they're not making applications to the court, they're just stopping contact. So can they stop that? Well, they're not supposed to, certainly not without good reason. And hey, nobody likes to think of themselves as the bad guy, right? But unless social services have been involved, unless there are perhaps ongoing court proceedings, or if there are ongoing court proceedings, that you're making the appropriate application, then no, effectively. And I liken the thing to the burglar alarm. If they're going to do it, they're going to do it. Your reaction to that will need to be following an appropriate route. Listen, there's a court system. People who come on the phone to me or the team are normally at a crossroads. They're either going to rely on the goodwill of their ex, which is normally gone, or they're looking for help from the court. Okay? All right, number 3. Unsurprisingly, I had a whole heap of questions relating to COVID. Quelle surprise. So there was a whole bunch of COVID. So rather than like catalogue all the, I mean, maybe I'll do a whole live just about COVID contact. But in this live, I'm just talking, I'm going to put all of COVID into kind of one bubble. See what I did there? Ah, dear. It's been a long day. So the questions that we had in relation to COVID were things like, can I stop my ex from seeing the children? What if my child is being sent into a household where there are very, very vulnerable people? Or can I stop contact if the other party are not social distancing? Listen, there were a bajillion heap and variations on a theme. So I'll probably do a dedicated live simply about COVID and contact. But the reason why I hadn't done so yet was because regardless of all of that, and I get that one size doesn't fit all here. I totally get that. Okay, you are preaching to the choir. However, government guidelines are really clear in that children can still travel between separated parents' home. You may not agree with it, okay? It may not even be possible or even practical, okay? But that's what the government have said. So if you are on either side of that fence, okay, that's the government guideline. I know, because we researched this before we came out live becoming to you, okay? Whether you agree with it or not, and listen, I say this a bajillion times, that one size does not fit all. But whether you're umming and ahhing about sending children to contact, whether you're perhaps a non-resident parent and who's being stopped from having contact, like I said, the government guidelines are very, very clear. If you need some help, okay, in accessing some of the avenues open to you, then shout and holler, or even drop a question down below. There are avenues, but there's the court. Now I get the court are backed up, but there is court proceedings that can help you if we're not getting any, if mediation is failing, if you're struggling to communicate with your ex, then straight away I would be advising that you seek help from the court. The point is that there are avenues out there. The problem that we're finding at the moment, first of all, there's a heck of a lot of confusion. There's a lot of confusion because people try and interpret a one-size-fits-all model. And when people are trying to interpret a one-size-fits-all model, then naturally they're going to try and apply it to their own case. And there are no exceptions. I mean, the government guidelines have not made any exceptions available. They've not said, well, if you're a child in this situation, if you're a child in that situation, it just doesn't happen. However, it might be interesting. It might be interesting for you. I do this often. I'm going to stop and start when I have questions pop up. Hi, Ron. Hi. How you doing? How long till a first hearing? Have sent forms off 5 weeks ago. Okay, so it used to be between 4 and 6 weeks that you'd get a court hearing. Now I caveat that because that was pre-COVID. Nowadays, it really does depend where you are in the country. There's been, I'd like to tell you that all the courts are singing from the same hymn sheet, but they're not. So different courts are doing things in a different way. They've got different admins, they've got different departments. So here's the thing. I would, first of all, Ron, I would ring them. Ring. Did I mention ring? So when I'm helping people and the court forms have gone in, I pretty much launched a campaign, it's the only way I could describe it, to constantly ring the court. I'm constantly chasing up courts. In fact, I had one, court, they'll remain nameless, but they have been trying, I've seen all sorts of stuff. So this one particular court was trying to do a court hearing. It was the first hearing without actually having a court hearing. What they were trying to do is do it on paper. Right. So I would ring the court and ring and ring and ring. Acknowledge the fact that you'll probably be on hold for half a day. You might have to take a whole day out of your life just to get hold of them, but keep chasing it up, keep chasing it up. What the courts are backlogged, there's no way around it, especially COVID, and that's not, it's a mixture of things actually. That's not just a case of COVID and the number of applications, but you know, staff are getting sick as well. So we're making do, guys. And FYI, in case you haven't got the memo now, but most court hearings are virtual. And by virtual, of course, right now, most hearings are done by teleconference. Make of that what you will, but that's what we're working with. All right. Number 4. So number 4, the common questions that we get asked are, what age can my child have their wishes and feelings heard? The straight, honest answer is it depends on their age and understanding. Sounds a little woolly, right? Well, before we used to have something called Gillett competency, and then a child would have to reach the age of 12 before they could determine what they wanted and have their voice heard. Today, it's not that case, and the reason for it is because you could have a really emotionally intelligent 9-year-old who totally gets what's going on, or similarly, you could have a really immature 10-year-old, for example, who doesn't get what's going on and wouldn't have the smarts to kind of just get it. So the Gillett competency, or the age of 12, it has been thrown out the window. Now it's based on age and understanding, and it's actually one of the factors in the welfare checklist. Write it down, welfare checklist. If you're going through court and you've got child proceedings on the go, it's something that you're going to need to learn, know and recite. Welfare checklist. It's the toolkit that the court is going to use, and a part of those factors of the welfare checklist is the child's age. So it's based on a child's age and understanding. So in reality, it just means that each individual case is on its own merit, because every child is going to be different. Sometimes people like CAFCAS or local authority will speak to the child and glean their wishes and feelings, but how much weight is attached to it, of course, that goes under age and understanding. Of course, it goes without saying, however, that the older the child, the more weight is attached to their wishes and feelings. I mean, you struggle to get a 15-year-old, for example, doing something he or she doesn't want to do. Okay. And then finally, probably by far the most common, I think, question that we get asked is, what happens if the court order is broken? So to be fair, it's a really good question. So I know a lot of people here who've been through court will probably already know the answer to this. So if you guys have a court order and it is being breached, then you have a mechanism called an enforcement proceedings. But it comes with some caveats, because life, so I certainly don't advocate, and the court obviously doesn't advocate any knee-jerking into court. So if you've got a court order and it's been breached, I'll always have a 3-strike rule, okay? Because life happens, kids get ill, you know, things happen. So the first time that a court order is breached, the very first thing I do is I'll write to the other partner, and well, you will obviously, and ask, say, look, you know, sorry to hear this has happened, can we reschedule, and propose a date to have that miscontact made up. If it happens again, you're like, well, you know, I know life happens, but so we'd write to the other partner again and say, look, you know, sorry this has happened, can we reschedule and propose a date. Because you're giving them the benefit of the doubt and you're taking into account life, basically. However, if it happens a third time, then I would always recommend that at that point we put in an application for enforcement. Okay. Now, actually, at that enforcement application, the court has got a wide powers of things that they can do. In reality, the court doesn't often do a lot. Believe it or not, courts don't like actually making orders. So I'd always say that I always talk about being the driver of your case. So people say, well, if they can't do very much, what's the point? I mean, the number of enforcement applications that I have had and come away with clients has been frustrating, to say the least, because I think, well, we're in court here. Why are they not enforcing their own orders? Here's the thing. If you don't make the application for enforcement, then you're silently complicit in what the other party's doing. So it is perhaps a more expensive way of going, look what they're doing. Look, everybody, look what they're doing. If there are enough enforcement applications, and boy, I have seen parties where there's constantly breaching the orders, then the court's going to want to look at doing something more radical. And that might be a change of residence. All right, Ron, I could just see your question pop up, my love. I've also applied for son to bear my name, 6 months old. I have another child in separate family who bears my name. What's the likelihood? Am I entitled to have my name put on birth certificate? I take his birth certificate. If I ruled in my favour. All right, a few things there. Ron, you have no rights. Just putting that out there. In fact, mothers have no rights, fathers have no rights. You do not see the Fathers Act 19 whatever. You do not see the Mothers Act 19 whatever. You do, however, have the Children Act 1989. So children have rights, parents don't. In fact, the only rights parents have is under the European Courts of Human Rights, and there's a right to family life. But I don't think that's applicable in your comments there, Ron. So names. So courts make a big deal about surnames, because a surname, much more than a Christian name, denotes roots, heritage, right? And courts do like to see that children have that reflected. Irrespective of whether there are other members of the family, the fact that if you have a child, Ron, and they need to bear their surname, then it's something absolutely you could be asking for, okay? But also considering it might be something of a compromise to maybe think of something double-barreled. I hope that helps. And if I ruled in my favour, I think if you mean if the court ruled in your favour, I'd love to see it where I go, well, this is my case and I'm going to rule in my favour. Sadly, it doesn't quite work like that. You have to have a court that rules in your favour, okay? I have to say, sometimes the court will grant you, they'll grant you the surname, and they grant you the surname. But like I said, often the surname is part of a bigger thing. Not always do people go to court over a surname. Sorry, not often. Often it's linked with other things such as contact. I hope that helps, Ron, okay? Anyway, guys, I hope that helps you for today. There will be probably another video. If you need any comments, just like Ron's done, just pop some deets in the comments. If you need something a bit more specific, don't forget, shoot and holler. We are here for you. Anyway, have a great evening, guys. Over and out.